Okay, we're online. Come on up. First, we've got various lists in whatever order you guys want to.
That's Tom, maybe.
Tom, you want to?
Beginning the study first.
Yeah.
They're ready.
All right.
Good.
Is my understanding, based on the agenda. Is that correct?
All right.
What's that?
The gaming study.
Yeah, the gaming study.
Mr. Chairman, I am bringing in the presenters from Spectrum Gaming, so they should all be online here momentarily.
Okay.
Did you get copies of that study yet? Did you just get it, or did we get studies?
Mr. Chair, Representative Larson, it's not, we haven't received the full study yet. As soon as we get it, we'll get it distributed.
Thank you.
Mr. Chair, I would turn this over to Ms. Jillian. She will kind of spearhead the gaming study portion of this with her team there.
Hello, everyone. Excuse me, I have a little bit of a sore throat here. My name is Julianne Barretto. We're from Spectrum Gaming Group. Today, our team is going to go over some of the scope and some broad findings from the gaming study that we are in process of concluding for Wyoming. Our report will be submitted to Wyoming the end of next week. With that, I'm going to let Joe Weinert, our Executive Vice President, go ahead and announce our team. Thanks, Joe.
Well, good afternoon, members of the committee, as well as staff and other members in attendance. My name is Joe Weinert. I'm Executive Vice President of Spectrum Gaming Group. Spectrum is a nonpartisan gaming consultancy. That is, we do not advocate for gaming expansion, nor do we oppose it. We specialize in studying the economics, public policy, and regulation of legal gambling worldwide. We've been doing this for 31 years, and I think that makes us one of the longest running gaming consultancies in the country. We have served 25 state and territory governments throughout the country. Just this year, we completed a study for the New Hampshire Charitable Gaming Study Commission that focused on that state's rapid expansion of historical horse racing machines. This year, we finished a study for the Massachusetts Gaming Commission that focused on the feasibility of sports wagering kiosks and retail locations. We completed an iGaming study for the Indiana Gaming Commission, and we are right now completing an audit of the Virginia Racing Commission regarding the operations of that agency. So we've been at this project now for about 3 months, and as Ms. Barretto just said, we are getting close to wrapping that up now. And we have members of our team here, led by the project director, Stephen Angus. Steve is our vice president for legal and regulatory services. And before joining Spectrum several years ago, he was a longtime assistant general counsel for the New Jersey Casino Control Commission. We also have Matthew Robe, who is our senior vice president for financial analysis and is our chief financial analyst. We have Ted Grove. Ted is our senior regulatory associate. And I'm sure joining us just momentarily here will be Paul Reineveld, who's a senior paramutual associate. So with that, I'll turn it over to the project director, Steve Angus.
Thank you, Joe, and good afternoon. And pleasure to address you today. Thank you. By way of background, Spectrum was retained by the Wyoming Gaming Commission to conduct a feasibility study of the current regulatory system and the authorized forms of gaming in Wyoming. During our evaluation, we reviewed the applicable statutes and regulations governing authorized gaming. including paramutual racing, historic horse racing, skill-based amusement games, online sports wagering, and charitable gaming. We also interviewed commission staff and evaluated the organizational structure of the commission and performed on-site visits at various locations for historic horse racing and skill-based amusement games. Notably, we also reviewed the legislative parameters and regulations in various states that have recently expanded gaming, particularly in historic horse racing and sports wagering. In our report, we were making certain recommendations that, in our judgment, would enhance the regulatory system and help the commission to fulfill its overriding mission to foster and promote public confidence and trust in the regulatory system and in the integrity of gaming operations. As Joe indicated, we expect our report to be completed very shortly, probably middle of next week. With that brief overview, I'll now turn it over to Paul Reinfeld, who I hope is on the call, to address paramutual.
Steve, Paul is on the call, but he is not yet a presenter. So let's skip past Paul for now while we work on making him a presenter.
Okay, and I'll turn it over to Ted Grove for an overview of the regulatory system.
Ted, you're muted.
There we go. Hopefully everyone can hear me now. I had the enviable assignment of interviewing the fine men and women of the Wyoming Gaming Commission staff. And as I expected, I found them to be hospitable, professional, dedicated, fully cooperative with me, and above all, devoted to the mission of the organization. I interviewed them, I reviewed their processes and procedures, as well as examined the statutes and the rules under which they operate. Let me first say that in my impression, the commission is an effective regulator of the various types of legalized gaming in Wyoming. And also, as you may know, in addition, they are charged with investigating illegal gambling in the state. So between regulating all forms of legalized gaming and doing investigations of illegal gambling, they have a lot on their plate. So based on our interviews and our examination of your statutes and rules that pertain to legalized gaming, we've developed recommendations to assist the commission in its mission. I want to discuss briefly 4 of them. Number 1, Wyoming has a law that requires a licensing decision on a sports wagering application within 90 days of receipt of the application. There's a similar law that pertains to skill-based gaming applicants. And actually that has a more constrained time frame of 60 days. The problem with these mandatory time constraints is that sometimes a proper licensing investigation takes longer for various reasons. We've learned from staff interviews that on rare occasion, conditional licenses had to be granted because the time period expired before criminal history records checks could be completed. And let me just make that clear. That means that people held a Wyoming gaming license without verification that they did not have a conviction for a disqualifying offense. And to be clear, this is due to no fault of the commission, is sometimes there's a large volume of applicant fingerprints submitted for review. But the commission is between a rock and a hard place. When the clock is ticking, they've got to decide on the application, and they don't have an answer yet from the FBI. And also in that vein, Spectrum knows from our own experience conducting licensing investigations for jurisdictions, both domestic and international, that a proper suitability investigation into multinational gaming companies, such as sports betting operators, often with complex ownership and accompanied by a long list of qualifiers, likely require additional time beyond 90 days. And notably, your paramutual licensing investigations, which are obviously tied to HHRs, they do not have any time requirements. So our recommendation is, through statutory amendments, implement an elastic process where the executive director of the commission could authorize the enlargement of a mandatory licensing timeframe upon a determination of good cause. Number two, Wyoming law contains a requirement automatically granting to a sports wagering vendor a license if he is licensed and operating in 3 other gaming jurisdictions. And again, that's a shall, it's automatic. They meet those qualifications of licensure in 3 jurisdictions, they get a license. With all due deference to the various gaming jurisdictions throughout the United States, the rigors of their respective licensing processes and suitability investigations vary considerably. But further, possible issues of concern may have arisen after they were licensed, and sometimes these licenses are granted for a period of 5 years. Such a licensing mandate is not best practice. We do not recommend that the Wyoming Gaming Commission continue with such a licensing mandate, but rather have each applicant submit to the standard Wyoming Gaming Commission licensing suitability evaluation. Number 3, I want to talk about conservatorship, which may be nothing on your immediate plate, but let me go through this, and I think you'll understand why I want to address it. During our review, we observed that the Wyoming gaming law does not create a path for the appointment of a conservator in the event that an operator's gaming license is revoked or possibly not renewed. Such a conservator provision would avoid a forced immediate shutdown of the gaming facility and result in unemployment of all employees, and remove concern of such consequences from regulatory decisions. You should consider implementing provisions for an orderly transition of control, allowing for the continuation of legalized gaming operations until such time as a new gaming operator can be properly licensed and take control of the property. Now, let me give you 2 real-life examples of what I'm talking about. New Jersey has such a law, and in 2007, they used it to appoint a conservator that allowed for the continued gaming operation of the Tropicana Casino following a failure to renew that license upon a renewal for cause. Contrast that with Pennsylvania, who does not have such a provision. In 2008, an operator of a major casino in Pennsylvania was indicted by the federal government on criminal charges. The Pennsylvania Gaming Commission scrambled and had to get court authorization for emergency powers to actually have a conservator come in and take over that casino and keep it open. Now, Wyoming, granted, does not have full casinos, so we can't compare apples to apples. But you do have HHR machines, often in satellite locations that are run by one operator. And I think that would justify such a prophylactic provision in the unlikely event that a licensing revocation were to occur. So again, our recommendation is to create a statutory authority for the appointment of a conservator. And number 4, my last recommendation, and there's several more in our report, and this has to do with the criminal code statutory tools for the criminal investigators on the commission. As you know, in addition to the regulatory duties, they're charged with investigating illegal gambling that occurs in the state of Wyoming. And during our meeting with the law enforcement officers on the commission staff, we discussed the challenges that were posed by the Wyoming criminal statutes that pertain to professional gambling, which is illegal gambling in Wyoming. And I'll be honest, I'm a former prosecutor, and your laws are pretty unclear. Several experienced investigators discussed with me the problems when they tried to work around the exemption of a bona fide social relationship. And again, that's an exception for prosecution in Wyoming. And furthermore, there's some linguistic ambiguity in the statutory definition of profit, which is a necessary element to bring a criminal case for illegal gambling. So we recommend commencing a dialogue among the police, the prosecutors, and the legislatures regarding possibly fine-tuning this language. And finally, in that regard, we talked about money laundering in Wyoming. And I think the most significant observation was that Wyoming does not have a state anti-money laundering criminal statute. Considering that legalized gaming landscape that currently exists in Wyoming, the commission law enforcement officers require this in their toolbox to ensure that money laundering offenses that occur in or related to the legalized gaming operations are prosecutable. You shouldn't have to rely on the federal government in rare instances to come in and see if they want to take over a case for money laundering. And further, even beyond legalized gaming, again, as a former prosecutor, money laundering statutes are useful for other crimes, such as prosecution of large-scale drug operations, certain white-collar crimes, and of course, illegal gambling operations. So enactment of a state money laundering statute with meaningful penalties for violations, including for evasion of filing requirements such as structuring, should be a high priority. Thank you for your time.
Okay, is Paul available now?
Yeah, sorry about that. I'm Paul Reineveld. I worked with Doug Reed on this project as the paramutual and racing experts. We primarily focused on the live racing, the breeding in Wyoming, as well as safety and the safety rules. We began interviewing the commission, Charlie, Nick, and team, as well as the 3 racetrack operators and the 2 horsemen's groups. We also took a look at and reviewed the facility inspections that the Gaming Commission had brokered earlier this year with the Equine Risk Management Group, LLC, and Associates. And we were pleased that these were pretty comprehensive studies, and many of the recommendations for safety and have already been implemented or are in the works. We reviewed the Horse Racing Integrity Safety Authority rules and regulations, as well as the Association of Racing Commissioners International, the ARCI rules, and where Wyoming could possibly need some additions to the rule book for paramutual wagering and horse racing. We looked at the migration of horses, where they come from to Wyoming, how they move about in Wyoming. We benchmarked the 3 racing facilities as well as the Wyoming as a whole as it relates to other racing jurisdictions within the Intermountain West, Southwest, and even into places like Oklahoma, Iowa, and Louisiana. Looked at the similar competition and also noted that Wyoming does require horses coming from other jurisdictions still in order to make the race meets go with enough horses. We looked at the breeding industry and the numbers and how that's grown immensely since the implementation of HHR, and continues to grow, and it's actually a fantastic program. But right now while it's providing horses for the race meets, it could not provide enough horses without the migration of horses from other jurisdictions to come and compete in Wyoming. We also looked at the 4th license and what that would mean to these metrics and to horse racing in Wyoming. And we looked at a couple different scenarios. Ideally, there would be, if the 4th license comes in, there would be very little overlap between facilities for both the horse population as well as the regulatory side of things and staffing by the WGC. And with that, I believe that Matt Rube is up next.
There we go. Hello and good afternoon. My name is Matt Robe. I'm with Spectrum Gaming, obviously. My job was to take a look at what you've got currently in Wyoming through the diverse spectrum of gaming that you have, HHRs, the sports betting, and of course the skill games, the SBAGs, and look at what's out there in Wyoming, what could be out there in Wyoming, and whether there's room for more or there's too much or too little or just about right. And not to sound like a fairy tale, but you're kind of in a Goldilocks spot. The SBAGs, the distributed gaming, skill-based gamings, you've got a decent amount of control on that because it's only at 21 plus establishments. You can only have four per location. You've got roughly 1,300 of these machines around the state, and they're in every county. HHR, as you know, or paramutual wagering, is approved on a county-by-county basis. So there are 13 of your counties that have it, and then there are many counties that don't have it. So it's difficult to capture the whole market when you can only play in 2/3 of the market. I thought that the skill-based games were a nice entertainment feature to have in bars. It didn't seem, from talking to owners, from looking at the operations, from going through the data, that people go to bars to play this thing. They play these things because they're at bars. They don't go to bars to play these things. So that was an interesting thing, as well as listening to some of the operators that I did and locations that I did speak with about how important it is to have that little bit of extra cash coming in on a monthly basis with almost no overhead in order to keep the lights on and keep employees paid. So I thought that was interesting. On the HHR side, there is a very good opportunity for additional HHR revenue to come into or to be developed in Wyoming. Much of it coming from up north from Colorado or from west from Salt Lake City on the Evanston side. A lot of that opportunity, some of it's being captured now by the new development down in Swan Ranch. Over on the Evanston side, something similar or a couple of things similar to that could target the population in Utah, but without knowing more about their specific plans and getting into their financials, it's hard to put a number or a time frame on when that development might happen. But suffice it to say, I think right now what you're getting is about 45% of the total potential, with the balance primarily coming from those two states. The other fundamental thing that we looked at was the availability of iGaming or digital sports, digital wagering, iCasino, so internet blackjack, internet roulette, internet slot machines. And in order to come up with an estimate of that, we look at what's going on in other states. How quickly did they advance? When it started out, how quickly did it grow? Given that Wyoming already has internet sports wagering, it's almost just like flipping a switch. A lot of people who will use the internet sports wagering platform will then say, hey, you know what? I can also play blackjack here, and do that. So the adoption rate will be much faster. In order to look at where we think an estimate is, we look at a couple of things. We look at population, we look at sports teams in the area, we look at income in the state, and we look at other gaming and other gaming opportunities. Benchmark that against the litany of states that already have it, and say, okay, based on these benchmarks against here's a range of where we think Wyoming could land based on these sort of metrics. And that was my portion of the project, and thank you very much for inviting us to do it.
And we're available for any questions that anyone may have.
Mr. Chairman?
Go ahead.
Yeah, this question is for Mr. Grove. Mr. Grove, in what state did you prosecute the anti-money laundering statutes?
I was a deputy attorney general in New Jersey for 17 years, and I actually was a co-chair of the Atlantic City Money Laundering Task Force for about 7, which was a combination of state and federal authorities.
Thank you.
Any other questions? Clerk, go ahead.
Mr. Chairman, thank you. Also for Mr. Grove, it sounds like you believe that the definition of bona fide social relationship should be tightened. A few months ago, Bill Gates, who's building a nuclear power plant in Kemmerer, Wyoming, visited the plant site, and as part of his visit, participated in a game of Texas Hold'em for a $600 stakes, I guess. Is it your position then you think that should be illegal, that he shouldn't be allowed to do that?
Well, I'm going to give you a lawyerly response and say that I'm not admitted to practice law in Wyoming. So, but I can tell you generally, the states do not outlaw poker games in residences where no one takes a cut of the game, right? If everybody has an equal chance of winning the money, it's not criminal as long as the house doesn't take a cut.
Further questions? Go ahead, Bill.
Thank you, Mr. Chairman. In your experience, when you're looking at a regulatory entity, what have you seen are the kinds of things that you would flag or consider flagging to demonstrate a regulatory entity that is at capacity or beyond the capacity to regulate?
Steve, I think that question's to you.
Yeah, we take a look at the duties and responsibilities of the various staff members and determine whether they feel that they have been capable of performing the respective assignments. In many cases, we get candid impressions from them that they need additional help. For example, in examining Wyoming's structure, we noticed that they do not have an in-house legal counsel at the present time. We rely on outside counsel. And in our experience, that is not a best practice. And one of our recommendations is to hire in-house legal counsel. It would probably start off with one attorney, but it might expand as gaming operations evolve. As an in-house attorney for 26 years with the New Jersey Casino Control Commission, I can tell you that on a daily basis, legal issues would arise that benefited the commission from having the experience of in-house legal staff.
Any other questions? Please, go ahead.
I don't know who with Spectrum to address this question to, but I guess I'm kind of almost speechless in terms of what I've heard. I hope the final report comes out with something more substantive what I've heard. I've heard Goldilocks, I've heard elastic process for time. I've heard things look good. We're struggling with some big, overarching, holistic questions about the structure and the future of this industry, including looking at bills that will limit the number of locations, try to sort out between local and state authorities who's regulating what, whether we can professionalize the Gaming Commission, whether we can come in line with federal mandates for racing. And I'm not hearing anything that's really given us guidance on the really big issues. Now, maybe there was some miscommunication in terms of the RFP. Maybe this is all the more the RFP asked for. But is your final report going to address some of these? To me, the important thing is we started down this path because we wanted a new industry, which was an old industry in Wyoming, which is horse racing, and to help our agricultural sector. And how do we really build that? And how do we do that without hitting saturation or getting corruption? And I'm not hearing anything except that it all looks pretty good, which begs the question as to why we've got all these bills in front of us to completely overhaul the industry. Is there some misunderstanding as to what we were looking for in that RFP? Maybe I'm misunderstanding what we were looking for in the RFP, but I'm not hearing a whole lot coming out of your recommendations that's going to help us going forward.
Well, And give you a brief answer to that, we're not going to be recommending overhauling the industry. We feel that the industry, from our perspective and based on our review, has been succeeding, generating substantial revenue for the state. As far as your question about corruption, there will be certain recommendations to strengthen the licensing system, which is the cornerstone of a regulatory system to prevent corrupt and unsavory influences. So there will be some substantive recommendations along that line. Today, we were under the impression that we were just to give a brief overview rather than go into every minute point that will be included in the report. But we do not believe an overhaul of the regulatory system is necessary. Far from it. As Ted pointed out, we think the commission is doing a very effective job regulating the industry. And there may be some bills that have been floated about. People have their various agenda.
Follow up, Mr. Co-Chair.
Please.
I guess what I'm saying is that we have bills here that have a pretty profound impact on the industry, and I'm hearing you say everything's fine. We may not need this legislation, but that's what we've been working on for 2 years.
Well, we don't address.
I just, like I said, I'm not quite sure what to say.
We're not addressing specific legislation. We could expand our evaluation if that's called for, but currently that was not our assignment. We're evaluating the current structure of the regulatory system, comparing it with what other states have done, and examine whether gaming could be expanded, whether that would be profitable for the state. And there are areas that we believe need to be improved. Ted went over some, and there will be others. But by and large, as a whole, our view is that the Gaming Commission is doing a very, very effective job. When we compare it to what other jurisdictions have done in recently expanded gaming, we stand by that. Now, I will say the skill-based games, Wyoming is one of the very few states that has legalized skill-based games. That is an issue that has been contentious in the United States, and we may be addressing that to some extent.
Okay, further questions? Go ahead.
Thank you, Mr.
I
Chairman.
hope that helps answer your question.
So,
Director, if you want to address those questions at some point. Oh, go ahead.
thanks. I'm following back up. Thank you for your high-level overview and kind of signaling of the substance of your report. Hoping to maybe get to work on some of the more detailed portions of your report. And I'm particularly interested in your identification of Wyoming's lack of having an anti-money laundering statute. And so that's actually a fairly, I think, easy lift for us to probably accomplish and to start that process now. So I've already put in a bill draft request for that. And just wanted to signal that to the community and to legislators listening. And back to Mr. Grove, the reason why I asked what state you were in was your familiarity with that state's statute for anti-money laundering, and obviously it's quite extensive, but are you pleased with New Jersey's statute for anti-money laundering? And is that a state's law that you would direct us to base ours from, or are there any other states that you are aware of that have some pretty good frameworks for that felony?
New Jersey does have a very robust anti-money laundering law. And just to take it further, in many of the gaming states, such as New Jersey, there's usually a component to the gaming regulations that require a sharing of the federal reporting requirements, such as currency transaction reports and suspicious activity reports that are filed by the gaming operator with FinCEN, which is the Financial Crimes Law Enforcement Network, which oversees compliance with the Bank Secrecy Act.
Right.
And it's in our report. Our recommendation for Wyoming is going to be have your rules require a gaming operator, such as one of the sports betting operators, when they file a CTR or an SAR with FinCEN, have them file it simultaneously with the Gaming Commission, so you can review it and act on it if necessary. A lot of the states, like New Jersey, have that requirement as well.
Yeah, and I would add, as far as money laundering, and we point this out in our report, there is a legitimate concern with respect to online sports wagering for a great devotion to prevent and detect money laundering operations. That is a very susceptible area.
And I just have a follow-up question, if I may. So in recognizing New Jersey's industry on this is significant and substantial, but I'm assuming that there is a dedicated law enforcement agency at the state level focused on this. Is that the state police, or is that within the Attorney General's office, or who is that in New Jersey?
Yes, actually, I can talk about that. In New Jersey, they have a strong attorney general. So there's 21 counties that have a county prosecutor, and then there's prosecutors at the state level, and that's where I was. And they generally handle cases of statewide significance. In New Jersey, there's a dedicated team of prosecutors that handle all the cases that come out of Atlantic City's casinos. And the investigators assigned to Atlantic City casinos are all state police. So it's all done at the state level. Within the state police investigation unit, there's financial crimes, there's specialized crimes, there's things like that. So there's certain units that focus on certain crimes. As I mentioned before, I was part of the Atlantic City Money Laundering Task Force, which is in Atlantic City. It's a combination of the FBI, Secret Service, DEA, the state police in New Jersey, the Attorney General's office, which I was part of, and various other agencies. And we would meet monthly to go over CTRs and SARs that were filed from Atlantic City's casinos and try to coordinate our investigations.
Yeah, thank you. And just to the committee, recognizing as this industry continues to develop that there's a lot of gaps of resources within our state of individuals with the capacity to provide resources to the entire industry, including criminal investigations, right? Our state police don't have experience with this yet, right? I mean, as it's ongoing, there's some paramutual, of course, has always been present. But there's a gap there that will need to be addressed. More money.
Okay, any further questions for the consultants? All right, thank you very much. We appreciate your testimony and we look forward to your report. And we'll probably hear back from us again.
Thank you.
Okay.
Thank you.
Next up is.
Did you want them to comment or anything on it?
Yeah, I'll ask him to. So any comments you may have, Director, on the presentation and any questions asked to the consultants, please speak your piece when you need to. Welcome.
Good afternoon. Charles Moore, the Director of the Wyoming Gaming Commission. And I have to apologize if I get out of breath here a little bit or start coughing. It's unavoidable. So, excuse me here. As far as some of the questions that were posed and brought up, with money laundering, that has been an issue that we've been aware of. And most recently, in fact, so those are concerned. As far as the RFP goes, we took the statutory language and put that with the RFP, and Nick actually, Mr. Laramendi actually did that. And I think that we will be able to answer the questions that you do have. And as we've said from the very beginning, once we have that initial draft of the product next week, we'll be circulating that to you all first before we see the final draft.
And so if we have any particular issues, we can throw out a question or two.
Mr. Chairman, I think that is correct, yes. Yes.
Go ahead.
So, Charlie or Nick, either one, as you've kind of reviewed and looked at that, and as you drafted the RFP, do you feel like you got the answers that we were looking for? And are you, does it spawn further questions? Kind of just tell us your initial, I know it's not the final, but just your initial reaction and if it's what you had hoped for.
Mr. Chair, Representative Larson, we have not seen the report yet either, so I can't really answer that. I will say that when the RFP was drafted, a lot of the language that was in the footnote for the funds that was set aside for this was actually placed directly into the RFP to ensure that the scope of the RFP was captured as it was allotted for.
Mr. Chairman?
Please.
Knowing what was in your RFP, do you think that the report we're going to get would affect our voting on these bills? Should we wait until we see the report to vote on these bills and see what we're really needing to do?
Mr. Chair, the way that the RFP was written, I know that there was allotments in there to look at all of the counties, the number of OTBs, the number of terminals, population size. So some of that could, I think could cover 219 and, well, it would be 219. As far as the local approval, I don't believe the RFP is going to have, or the study is going to have anything to do with that policy decision for you all, if you want cities or counties to ultimately have say in how that looks. I know that they had touched on the composition of the Wyoming Gaming Commission, so that probably will be covered in the report. The breakage will not be covered in the report. And the gaming amendments bill, there might be certain things that are and certain things that are not. It's hard to say.
Okay, further questions? Please proceed. Anything else?
Mr. Chair, I think we're good with this if you are, and we're ready to move on to the next ones, the bills.
Okay, I think we're ready to start picking up the bills. You want to take over, and I'll let you run the, go ahead. Well, except unless you want to comment on them a little bit. No, I'll let you do it.
Mr. Chairman, again, thank you very much for having us here today. Most of you know Nick Laramendi, and Nick will be taking over for me at my retirement after the first of the year. So I'd like to welcome him. I hope you all can embrace him as you've embraced me over the last 17 years, and I appreciate everything. I'm going to be kind of behind the scenes through January, giving Nick if he has any questions, any concerns, but I believe that he's going to be a phenomenal person in this position, and I think we're all very fortunate to have him here today. So, thank you. Thank you for everything that you have done for me over the years.
You bet. Thank you. Thank you, Charlie. Only 17 years.
Mr. Chair, if I may, I would also like to thank all of you for the work on the footnote for the dual filling of this position. 17 years of experience sitting on, national boards in all things gaming. Charlie is a encyclopedia of knowledge. and I'm taking copious amounts of notes every day. And his black book of contacts across the industry are large as well. So it's been invaluable, and this is going to continue to help during this transition. So thank you all. I appreciate it.
Okay, go ahead, Tom.
Thank you, Mr. Chairman. I think next on the agenda, Mr. Chairman, is to start through these bills, and I think just go through them the way they're listed on our agenda. Have Ms. Revely maybe give us a high-level overview of each of the bills. We've seen each of these prior meetings, and maybe highlight a few of the differences since our last meeting, but I think we're ready to proceed. And it would be 25 LSO 51, local approval for historic horse racing permitting. Go ahead, Tamara.
All right, you ready? Again, I'm Tamara Revely with the Wyoming Legislative Service Office and staff to this committee. As you all know, you've been considering gaming at each of your interim working groups this year. And at the September 7th meeting, you had 7 bills before you. You received a lot of public comment. The working group requested that written comments be provided, and they did receive comments from Wyoming Horse Racing, Wyoming Downs, and 307 Horse Racing. The working group met on August 14th remotely, and they received assistance from Wyoming Gaming Commission and the governor's office as well. And they incorporated those comments. They discussed all of the comments and incorporated them to some extent and made other revisions to the bills. And I'll focus a lot on what those revisions were rather than on what all the bills do, since you've looked at them a few times now. All of the bills were changed except for the consolidation bill, the big bill that would just renumber all the statutes and attempt not to change them in doing so. So that first bill that we'll talk about is 25 LSO 0051. It's working draft 10.10. It's called local approval for simulcasting. And the big changes that came into this bill was to not just limit it to HHR, to historic horse racing, to bring in simulcasting and historic horse racing, since those industries are so tied together in Wyoming. The second change was to limit the conditions and revocation that could be made to qualify those somewhat. And the third change was to specify some level of judicial review. The fourth change was to repeal a steward requirement for simulcasting or historic horse racing. And then the fifth big picture change was addressing the treatment of existing permit holders if this bill goes forward. So I can point you to the specific text of those changes if you would like, or describe them in greater detail.
I think it's important.
Okay. Sure, okay. We'll go through quickly then. This is the local approval for simulcasting. It's created in a new section. This new section is useful because statutes are somewhat limited in how much simulcasting is described, and it's sort of hard to come in and amend how simulcasting works when it's only mentioned in a couple of places. So this creates a section for simulcasting permitting and then addresses the approval by cities, towns, and counties. On page 2, this is mostly the existing framework that you saw at your last meeting. The Gaming Commission would still approve permits, but approval would be required for cities, towns, and counties, and that brings in cities and towns. Approval is not currently required by them, just for counties. The commission would still promulgate rules. That's recreated from statute. And generally, the terms for simulcasting would be just like they are for paramutual, except where this act specifically has some changes and conditions for cities and towns and counties. The simulcasting would be subject to the requirements that a city, town, or county, depending on where the proposed location would be, whether it's within the city limits or out of the city limits, it would be subject to approval by that entity. It'd be good for 3 years, and it would still only be allowed to be issued to somebody, to a permit holder authorized to conduct a paramutual event. In other words, often live horse racing or another paramutual event. I think we want to jump into the first big change was to somewhat revise when a city, town, or county in granting its approval could condition and what conditions they could make. That's on page 5. Paragraph 3, it now words that with respect to the renewal and issuance approval of simulcasting permits, applicable city, town, or county may only impose the following conditions. Previously, this was just a list of the conditions that could be imposed. Now this is a exclusive list of conditions that could be imposed. The first is a schedule of operating hours, and provided that the hours of operation shall not be more restrictive than that which is set for alcohol sales for retail liquor licenses under Wyoming Statute 12.5.101 and 12.4.201. And those statutes require local licensing authorities to uniformly set the hours of operation for establishments and permit holders of alcohol liquor licenses. Then the second condition would be designations within the permitted premises relating to the areas that the historic horse racing machines could be located, to the extent the designations are not inconsistent with the rules of the commission. With that, on the bottom of page 5, paragraph 4 is that the city, town, or county may modify the conditions imposed under paragraph 3 only upon a showing of good cause. That only was added. On page 6, the language in paragraph 5 was revised. Now says the city, town, or county shall identify the specific location in the city, town, or county where simulcasting is approved to be conducted, and the number of historic horse racing machines to be permitted at that location, if any. Paragraph 6 says it shall grant approval the same term as is granted by the commission for a simulcasting permit. The prior version of the draft contemplated that there might be instances when a city, town, or county met on a regular schedule that would be less than 3 years, but now it would be for 3 years or whatever was granted by the commission. Paragraph 8 says shall have the right to revoke its approval or deny a renewal or approval for a simulcasting permit only for good cause, and then limits good cause to a breach by the holder of the permit that's not cured within 60 business days. The prior version was 10 business days. On page 7, a determination by the applicable city, town, or county or commission that the holder of a permit or any employee or agent thereof has acted in violation of the Wyoming gaming laws. And this was changed from being any violation of law to being a violation of Wyoming gaming laws, and then to also make clear it included employees or agents of the permit holder. And then subparagraph C was not changed. Revocation, good cause could also include the welfare of the people residing in the immediate vicinity. Paragraph subsection H was not changed except to remove provisions for modifying terms in light of the prior changes we talked about. And then on page 8, subsection J was created that says an applicant for a city, town, or county's approval for a simulcasting permit or the holder of a permit may appeal to the district court in the county where the permitted premises are or will be located from an adverse decision or revocation. The working group talked a bit about this and how closely to model it on the revocation statutes that exist for alcohol licenses. This is where they came out. It is somewhat of a complex subject with how the Administrative Procedures Act applies and what a court may decide. The alcohol statutes are a little different in that they also have some specific direction on how a denial would be appealed to the district court, and that the court would consider it de novo, except that the record could be brought in and that the rules of civil procedure would apply. The working group chose not to bring that in at this point. Section 2 is the amendments.
Mr. Co-Chair. Yeah, before you leave that, Tamara, I've got a couple questions. So going back to page 4, subsection G, everything thereafter applies to either initial approval or renewal, correct? So pages 5, 6, and 7 all apply to either an initial or a renewal?
That's correct.
Okay. And then, so on page 5, they may impose only the following conditions. That's Romanet 3, which is operating hours and where they can locate the machines. But then 4 does not seem to be limited by Romanet 3. And under 4, they can actually pare back the number of or 5, excuse me, they can pare back the number of machines. So if an operator's got 40 machines on renewal, they could say you get 10. Am I reading that right?
Mr. Chairman, that's a good question. I don't believe the intent, I think the intent was just to, in their permit, to list and identify the number of historic horse racing machines that would be permitted at the location, not to set the limit. But you may raise a good question of how this would be interpreted and what kind of specific intent you want to convey in it.
Okay, I guess I didn't read it any other way. Tell me, with respect to the renewal of permits issued by the commission, the applicable city, town, or county, 5, shall identify the specific location where simulcasting is approved to be conducted and the number of historic racing machines to be permitted. So you were thinking that was just a simple listing of what was already in their permit as opposed to saying, we're going to change where you can do it and how many you can have?
That was my understanding of the intent of the working group, but I'll let them comment if they saw it otherwise.
Mr. Chairman, the LSO drafter stated it just perfectly. Our intent in 5 was to say that in the application, you will tell the municipality or the county the address where it's going to be located, essentially. So it's not a blanket, go to them and get approval to have these machines, and then they could put them wherever they wanted within the community. It is they go to them to get approval for a specific location, and that's what page 6, Romanet 5 is referencing. And then it will also identify at said location the number of machines that will be permitted at that location.
Mr. Co-Chair.
That was the intent of our working group in the drafting as we had Ms. Revley drafted.
So, Mr. Co-Chair, I just want to make sure I'm understanding what Representative Walters was saying. I get it if it's the initial application, they can talk about where. I didn't know that we intended to, on an initial, that we were going to start limiting who can have how many machines, but most particularly I'm concerned about on renewal. If you're saying, I'm unclear, are you saying on renewal the intent is that they will not change the number of historic racing machines nor change where it's to be conducted?
Mr. Chairman, our intent, or the way, and I'll hopefully not stepping out over my skis too far with the intent of the committee, but the intent of the committee is yes. On a renewal, the renewal is assumed to be at the same location for the same activity. If the things are changing, then that needs to be notified. If you're moving that location from one side of town to the other, from one side of the street to the other, that is more than a renewal, and that's no different than as we've said, a lot of this is somewhat modified or tracking our liquor laws. So if you're moving your bar location, it's not just an automatic renewal for your liquor license. You have to notice that, and you have to explain to the county commission or the city council that you're moving your bar. And that was really the intent of this. If you're moving your operation, and if you're an operator with multiple operations in one community, if you're on the renewal of that particular location and you plan to move it somewhere, then yes, it becomes greater than just a standard renewal. It will be seen as not necessarily new, but it will certainly be seen as a change in what you're doing. Now, if your renewal is at the same location, same machines, then 5 really doesn't have quite the impact that it does if you're moving that location.
Mr. Co-Chair. So Tamara, it's on me. I guess I'm more confused than I started. I didn't read this to give them the ability on renewal if they were changing locations to change the number of horse racing machines. What I heard Representative Walters say is that that the local government can't weigh in if it's the same location with the same operation, but can weigh in on where they can do it and how many machines they can have if they're proposing to, on renewal, change their location. Is that the way you're reading this? I'm not seeing a reference to a change of location in a renewal permit here on limiting Romanet 5.
So, Director, you may want to jump in on this, but I think all of this is predicated on Romanet 2, because what we're trying to do is prevent dual jurisdiction, or who has jurisdiction over what. And so what we don't want to do is have local municipalities or counties impose conditions that are inconsistent with what the powers and authority of the commission. And so all this does is set out a few instances where cities or counties can do certain things and to align it with the authorities of the Gaming Commission, because a lot of the testimony that we received was they didn't know what authority they had and where the line was drawn, and also that no one knew what the enforcement powers were. And so part of this line item identification kind of helped address those issues. Is Tamara, am I up a wrong tree or?
Yes, Mr. Chairman, I think that's correct. I think if the committee would like to provide further direction on the difference between a renewal and an application and how much authority the local entity has to specify or to limit the number of machines or the locations, I think we could make some drafting changes if this isn't as you intend, but I think the draft currently accomplishes what the working group set out to.
Yeah, Mr. Co-Chair, so I hear what you're saying. Then there would need to be language somewhere, either in Romanet 2 or Romanet 3, that extends the reach of 2 to much of what's laid out in 3, because 3 could be read to go beyond. You know, if 3 can be read to say that they can, on renewal, they can modify their location and the number of machines, then that goes beyond what I think you said, which is that's really the purview of the commission, and there's not language that's so doing. And then on page 6, Romanet 8, over to 7, subparagraph B, we've got the applicable city, town, or county determining that there's been a violation of gaming law, which should be within the purview of the commission. Now you've got localities determining gaming law violations in renewals, when really that should be the purview of the commission, not the city, town, or county. So there needs to be some language paring back what's going to happen on these renewals.
Actually, that provision is a little different. That's the inverse, I think, of what you just said, Mr. Co-Chair, and that is that the thought was that if you're going to take away a gaming license, it should be taken away because of a violation of the gaming laws. If you had minors under the influence or serving to minors or things like that a staff member happened, those are things that shouldn't necessarily mean the loss of your gaming license unless the Gaming Commission did it. But you could lose your liquor license or your operations to do those things. And so that's the purpose of that particular language.
Mr. Co-Chair, I can see reading that on page 6, line 18, of conditions, so forth, that aren't cured and written notice. But on page 7, line 4, this is a violation. Has cities, towns, and counties determining there was a violation of gaming law. on renewal, which should be within the purview of the commission. Now you've got two different bodies. You've got the localities as well as the commission determine their violation of gaming laws.
Well, not to be argumentative, but there has to be a determination by the county or the city that there was a violation. They can go to the commission and the commission say it wasn't a violation. If they still believe it's a violation, they can pursue it if they choose to. And that's, to me, that is not inconsistent one with the other.
Mr. Co-Chair, why wouldn't you say that if there's a determination by the commission that there was a violation of the gaming laws, and then it falls to the locality to determine whether that violation is sufficient to repeal their renewal?
It would be. But on the other hand, the city may say, we don't think it was a violation. I don't see a hand.
Representative Stith, was your hand up?
Mr. Chairman, yes, it was. I don't know that.
It was.
It was. Well, so let me make two comments. One is I think Senator Kinski has a fair point with respect to Romanet 5 on page 6 that as currently drafted, it does seem to allow the city on renewal to, just pick a number for what light machines will be approved. And so I don't think that's the intent. So we probably want to tweak that. On page 7, I don't have as much heartburn with a city going into a historic horse racing establishment, and if they happen to be running a full casino with blackjack, craps, and roulette wheels, it seems like a city ought to be able to say, hey, we don't like that, and be able to say we're going to revoke your license because we can see that you're not, that you're violating the gaming laws. So that's my 2 cents, and I'll stop talking.
All right, section 2.
Okay, another one? Any more? I would concur that Romanet 5 needs to be reworded. It's confusing. So. Okay, you want to proceed?
Sure, Mr. Chairman. I think we're moving on to the amend section in section 2 on page 8. This didn't change drastically other than some tweaking and improvements to definitions and language as worked by the working group with the input from the agencies. The amendments would be to include an amendment to paramutual event and to make clear that wagering on historic horse racing machines was included. And we strike lines 3 through 9 because we're now recreating much of that in the new section and within the new definition of historic horse racing machine. On lines 14 and 15 is an important strike. This strike corresponds with a repeal that's going to be in the last section of the bill before the effective date. It begins with the commission shall authorize simulcasting subject to the following conditions. And this is really the existing statute, the biggest area of existing statute that controls simulcasting. It's within the definition of simulcasting, and this requires the commission or limits the commission in approving simulcasting only for permit holders of another event. It has the 100-mile restriction, and then it has the county approval. So we begin by striking this language that starts off the conditions, and then within the repeal section, you'll see those actual subparagraphs repealed. And the first, or 2 of them are recreated in this bill. The 100-mile is just left out. This bill creates a definition of historic horse racing machine, and that makes it helpful to refer to the machines throughout the bill, rather than having to use wordy language about historic paramutual events that have previously occurred that are simulcast. That definition didn't change. On page 10, this area changed. This is the requirement in existing law that stewards supervise each simulcast location that is approved by the commission. The prior bill draft had attempted to tweak that to be general supervision, and now it just strikes it all together. on. Page 11 is some conforming of the existing paramutual requirements for permitting paramutual events. Right now, on page 11, line 5 and 6, it requires that if a paramutual permit is to be issued, it is to have been approved by the Board of County Commissioners. This would make an exception, except as provided for simulcasting permits in this newly created section 210, and that is the exception of when cities and towns are required to approve rather than counties. On page 12, we are able to use that new definition of historic horse racing machines. Same on page 13. And on page 13, section 3 contains that repeal. And you can read the language that's being repealed on page 14, the A, B, C, and D. Those are currently the conditions on simulcasting that are created in the definition of simulcasting. And so this bill draft does have the nice addition of moving those substantive requirements from a definition to its own section. Section 4 is the applicability section, and it did change slightly. Subsection A didn't change too much. That says, notwithstanding this new section, the holders of simulcasting permits that are issued before the bill is enacted shall be continued to operation subject to the conditions of their permit until June 30th, 2026. Then on and after July 1st, 2026, all applicants for a simulcasting permit or renewal shall be subject to the new requirements that are created in this bill. This new sentence that begins at the end of line 7 on page 15 clarifies that existing permit holders are to be treated as such, because technically they're not existing permit holders. If a city or town now needs to grant its approval, they've never had the opportunity to grant approval before because they didn't have that authority. And so this just specifies that they shall be treated essentially as an existing permit holder, such that a city, town, or county may deny or refuse to renew only upon a showing of good cause. Just like it would be treated going forward, in order to revoke or deny, it would need to have good cause, as created by section 1. I think those are the major changes and a pretty thorough summary of what the bill does or would do.
Okay, further questions? Seeing none, we'll open up the public comment. Come on up. And don't be hesitant, we got lots of chairs up here, so. Please.
Good afternoon, Mr. Chairman, members of the committee. I'm Jeremiah Riemann here on behalf of the County Commissioners Association. I'm very proud to be here with Laramie County Commissioner Gunnar Malm. I'll provide some comments. I know that he has some for you as well, and I've also handed out some amendments that I'll very briefly go over. Mr. Chairman, why is this issue before you? It really comes down to the fact that Wyoming state law is largely silent around what our responsibility is in this local governance issue. Currently, Wyoming Statute 1125-102A, Romanet 7B, says that county commissioners can grant its permission. It's really a yes or no. That's it. It is silent as to whether we can impose conditions around that or whether we can't, whether it's just simply a yes or no. Right now, there are a few counties that have imposed conditions within their approval. Laramie, Goshen, Converse are good examples for you. Other counties that have authorization for HHR to exist in their communities are leery. I'll just use Teton County as an example. There are currently no HHR machines there, despite the fact that the voters have said it's acceptable, and it really comes down to they're not certain whether they can impose timing restrictions, location restrictions, and other things of that sort. And so it really does come down to what can we do? So we've come to you with a request, and I really appreciate you taking up this issue. I presented a draft to you in June. It's a draft that I spent 18 months working with 307 Horse Racing on. So I didn't do it on my own. I worked with one of the operators and brought it forward. This bill has morphed a bit from where we started, and in some good ways and some unfortunate ways, and we can get into that. I do want to have the commissioner talk about the importance of having some additional powers, and then, as I said, I'd really like the chance to go through my amendments very briefly with you.
Mr. Chairman, Committee, Laramie County Commissioner Gunnar Malm, very much appreciate the opportunity to come and speak with you today. So I've been a commissioner for 6 years. In that 6 years, I've been across the street at the Supreme Court 2 times. One time on a statute that had or lacked the ability for Laramie County to dissolve a fair board, so it was silent, and another on ambiguous language as it comes to land use and the issuance of a permit for a gravel quarry. We lost both of those cases, and ultimately the issues had to come back to you to be fixed. And I think that this is a great example of where that could occur again. It's silent on our ability to revoke a license if there is an issue. And I would preface that by saying we have a great relationship with all the operators that are currently going in Laramie County and in Wyoming. And I don't anticipate a change, but things do change. So without that authority, it makes it very risky for the county to continue to issue permits. But we also have the potential of making an arbitrary and capricious decision in the future by denying a permit, because there's no outline of what is allowable. And we've already opened the door by allowing 3 operators to operate in Laramie County. So if a 4th one came and we said, you know, Facebook comments say that there's too many of these in Laramie County, and I'm sure Representative Nicholas could attest to walking door to door and people telling him that, you know, Laramie County has too many gaming machines. But that's just a feeling and an opinion, and we can't base governance and policymaking on something like that. So we need hard data and information to be able to make a determination, or else we will get sued and we'll lose for making an arbitrary and capricious decision. I know, I've been there, it's happened. And so I would ask that this committee take into account what Director Riemann will bring forward and work to kind of close some of these gaps in this legislation and in gaming that has provided good revenue for Laramie County and the state of Wyoming, and that we can move forward in a positive way. So, thank you.
So, Mr.
Questions for Gunnar? Please, go ahead.
Yeah, Mr. Chairman, if I can, just briefly, if you know, do you know how much this industry has brought into Laramie County over any period of time? What it means to Laramie County?
I can't hear you, Senator Medica.
How much money is the industry bringing into Laramie County, do you know?
Mr. Chairman, through you, Senator Nethercutt, $2.3 million
Over what period of time?
in 2023.
Amazing. Okay. Thank you. Any other questions for Gunnar? So do you have, what, obviously, the question then is, if you feel this language is insufficient, or if you want other reasons to deny the permit, I think what we need is just crafted ideas, or what you would like to do, under what terms or conditions, so.
Mr. Chairman, I think that what was laid out in the gaming report, the things that they didn't get to in terms of saturation levels and things like that, is data that's important to Laramie County and cities and towns when they're making these decisions. We get those numbers from industry, but obviously we don't have true numbers about what that level is in Laramie County for what is acceptable beyond perception, right? I think there's probably too many coffee shops, but one opens up every single week. So some capitalist is still deciding that it's a good investment. And if these businesses are still deciding it's a good investment, who am I to say it's not?
Well, and I think we would all concur with that it shouldn't be the industry's definition of saturation level. It ought to have some local control to it. I think that's part of our intent. In fact, the one thing we haven't seen, but we were considering and still are considering, is putting a moratorium on it until we figure out the answer to that. And we discussed that in some of our meetings, so I understand that completely. It makes sense. Okay.
Mr. Chairman.
Go ahead.
So, Commissioner, am I to understand you then that you feel that in order, we've asked you what amendments you'd like to make or how you see this to help you, and you're trying to tell us that you need the ability to make appropriate decisions for the benefit of the county and in your constituents. And then am I hearing you correctly that you would like to be able to digest the report before we do that, or tell me, I didn't make that connection.
Mr. Chairman, through you, Representative, I appreciate that. I do think that as it relates to this bill particularly and the abilities within it and the powers granted to counties, cities, and towns in terms of revocation, it's probably sufficient to move forward in this manner. But as we digest the report, you digest the report, and we see what other remedies may be available for the expansion of gaming throughout our communities, we could revisit a different solution. So.
Thank you.
Jeremiah, go ahead.
Thank you, Mr. Chairman. I do want to be brief, but I want to hit each of the amendments that I've put before you today. Mr. Chairman, I also want to reiterate that we have a great working relationship with the operators, and I've tried to work with them on these various amendments before you. As I stated in the outset here, currently counties are in the leadership role. And it's one we've proudly served, and we're happy to continue serving in that leadership role. But we're also not opposed to having municipal approval as part of this. That said, specific to my first amendment before you, the way that this legislation sits before you today, you're taking counties out of the process as it relates to the vast majority of permits that are currently in place in the state of Wyoming. And I think it's important that counties remain involved. Maybe we're not making the specific, what streetlights have to be there, the signage and other things of that nature, but counties should remain there. Why? Remember, the approval for HHR is a countywide vote. It's not a municipal or an unincorporated vote. It is a countywide vote. And as I said, all existing approvals and agreements related to HHR operations in the state of Wyoming are with the county. So I've simply provided you with a general rewrite of what exists in current state statute for counties to continue to provide consent, but leave in place the municipal component of this, whereby they would be granting approval and also granting or stipulating conditions to be imposed. That's what Amendment 1 represents.
Thank you, Jeremiah. So, and I may not understand as I'm reading that, but it says, so they can, simulcasting can only be conducted off permitted premises if the county commissioner consents. But if this is within a municipality and they approve it within the municipality, and there's a conflict between what the municipality says and what the county says, how's that resolved?
Mr. Chairman, if the county does not consent, then the operation does not move forward.
And so, Mr. Chairman, so would there be some perception, Big Brother, that you're controlling what little brother wants to do?
Mr. Chairman, perception, that's up to every one of us as individuals. I want to be really clear that as it relates to these things, and I think that the council member here and the commissioner, they work very closely together and very positively, but perception's in the eye of the beholder.
Thank you. But it's an arguable conflict, correct?
Mr. Chairman, yes.
Thank you.
Mr. Chairman, with this amendment, I think that just completely defeat the purpose of the bill. The bill's goal was to give each type of jurisdiction their own control. And with this, we say, yeah, we'll give the cities, towns control, but the county still trumps everything. And that was not our intent. Our intent was to say if the activity is occurring in the county gets to control, and if the activity is occurring within the city-town boundaries, then the city and town gets to control. And then we lay out a few provisions as to what they may impose that are above and beyond or still considered within state statute, but without giving the local governments carte blanche control to prevent these activities from taking place when the state says it's okay. And so that's why I struggle with your First Amendment that you're proposing, because we're just hitting reverse and we just will stay right where we are today. Because actually, with your amendment, if we were to include it and pass this bill, we've made it more onerous and more problematic for an operator to operate, because now they're going to have to get 2 approvals for something they only have to get 1 approval for today. What are your thoughts on that?
Yeah, Mr. Chairman, first off, every municipal resident is a county resident. So the county commissioners have an interest in this issue. Number 2, right, wrong, or indifferent, when you crafted this legislation or the enacting statutes here, you imposed the responsibility on county commissioners. So the county commissioners have been in this leadership role all along. Number 3, when you crafted it, you made it a countywide vote relative to whether these operations should or should not exist. So that's an important component here. Mr. Chairman, I think the other piece that's really important for you to consider when you look at this stuff is that a lot of the issues that you might hear about relative to gaming might revolve around law enforcement. Well, in several of our counties, law enforcement is entirely the responsibility of county sheriff, not municipal police, the county sheriff. And that exists in many of your jurisdictions, even if it's not a countywide setup. The second thing that I would say under that umbrella is that you've given counties, not municipalities, the responsibility for gaming and mental health and substance abuse services. You know, if we look across all of the various gaming bills that you've set up, you're sending money to counties to deal with problematic gaming. So we have a responsibility there. We also ultimately have prosecution responsibilities. So all of these things say that the counties ought to have some sort of interaction here, even if it happens to be in a municipality. I'm not sitting here to say that the municipalities shouldn't have a role. I've been defensive of the fact that they should have a role. And the way I tried to construct this language was to say, hey, yes, the county commissioners get to consent and ultimately perhaps have a veto here, but when it gets down to the municipality and the specific conditions of approval, I'm trying to take us out of that role. So yes, there might be 2 places that you stop, but that's probably no different than what exists today when the operators have to go get the approval of the county commissioners and then have to look at what the zoning overlays and other things exist and deal with that. So, Mr. Chairman, I suggest that we would adopt Amendment 1.
Okay.
Mr.
Next.
Chairman,
Go ahead.
I just wanted to share how much I'm enjoying watching the discomfort between the cities, towns, and counties. It's nice to have that discomfort not always directed at us over here, the entertainment. So I appreciate your efforts for diplomacy, as ineffective as they may be, watching your faces. So thanks.
You want to go to your next amendment?
Yeah. Thanks, Mr. Chairman. The second amendment deals with the cost of publishing. There's a provision on page 4, line 1 that says that we can only charge that which is determined by rule of the commission, the gaming commission in this particular instance. It's my suggestion that we should be able to charge that which is sufficient to cover the costs. We're not looking to actually make money on this. We're just trying to cover costs, which is what the statute says there without that rule. And I just think it's an unnecessary rule.
Is 2.3 million enough?
Mr. Chairman, frankly, the cost of that should be borne by the applicant, not by the local government.
Mr. Chairman, and Mr. Laramendi, on that note, as you've set it in rule, have you set it high enough to where it does cover that? The permittee's paying enough to cover it for the local government? Or are you charging enough now for the local government to cover it? The advertising piece?
Mr. Chair, Representative Walters, currently there is no advertising piece that we charge anything for. And there's no application fee given to the commission for a site-specific location as well.
And Mr. Chairman, to be clear, this is a new provision in law that would require us to actually go out and post something, which is not something we have to do right now. So we're just simply asking, and this is language that is mirrored to our existing liquor license laws.
Thank you.
Mr. Chairman, going to Amendment 3, which is on page 5, to an earlier comment about the merits of moving forward a bill. If this bill stands as it is with provision 3 on page 5, we ought not to move forward. I mean, the reality is county commissioners are exerting more control than what this legislation states right now. This limits our ability to control two things. One, the schedule of operating hours, which are dictated by these statutes. So we really don't have any power. We're just going to put that into a permit. And two, where these machines can exist within a permitted premises. That's, again, we ought to not move forward with the legislation if that's all we're going to do. And so I've suggested an amendment that says these are two of the things that we can do, but there are other things that we might be able to impose. We could perhaps come up with some other language that could go in here that accomplishes your limitation, but as it stands, this is far too limiting in the way it's constructed.
Mr. Chairman, so on that front, our working group went up back and forth on this for an extended period of time, trying to come up with what is the best way to address this. With our biggest concern being the vote of the people says that it's okay in the community, but then the local government, the members don't like it. And so then they come in and put in such restrictive requirements that an operator couldn't operate. And so that's what we were trying to prevent, is trying to figure out a way to say, hey, this is allowed here, so you're going to allow it, local government. And we're only going to give you a few ways that you're not going to allow it. Now, are there a few more maybe we should add? Possibly, but the whole intent here, and like I said, we spent a significant amount of time trying to figure out how to craft this so that the situation I just described didn't occur, in that the 5 city councilmen or 7 city councilmen or 3 county commissioners or 5 county commissioners didn't, just because those few members didn't like it, didn't shut down the entire operation that is already legally allowed because it had been through the other steps. And so would gladly welcome some ideas on how we can move forward on that front to accomplish both those tasks. And so I recognize your concern and want you to know that we recognize your concern as well in our working group, because that was something of considerable note. And obviously, this is where we landed, because we said we have to put something forward and have it out 2 weeks prior to our meeting. We couldn't, and we just met just barely over a month ago in Douglas, so we didn't have a lot of time to get comments, get the work done, and get it out in a timely manner so that the public could see it. But now that you understand where we were coming from, trying to figure out the best way to craft it, we do share the concern, would take comments on, or suggestions on that.
Representative Stitt.
Mr. Chairman, thank you. Mr. Riemann, following up on what Representative Walters just said, could you give us 2 or 3 examples of conditions that a Board of County Commissioners might want to impose that they would not be able to impose if this were passed with the current language?
Yeah, Mr. Chairman, I could go off of a number of things. It could be signage, it could be access into a facility, it could be again, where machines are within the location and keeping those from underaged individuals that shouldn't be able to access these. These are all sort of the general welfare, public good things that could come. And I'm happy to continue working with you to broaden this, but I'll just say my commissioners have been working on this for a number of years, and we've had no issue with trying to put provisions in that operators have been agreeable to, and the industry is growing. So, I was out for Halloween last night, and I didn't see a whole lot of ghosts, and I don't think that we need to create ghosts where they're not, too.
Well, every example you just gave, you already have that authority with this language. So I think we just got to take a deeper dive on it. Those are inside what your authority are, regardless of this language. So go ahead.
So Jeremiah, one of the things we talked about in the working group was such things as zoning requirements where physically in the area. Isn't that, instead of getting down to the micro, but the macro level is, we talked about the number of machines, but where they can be located within the county, or where they can be located within the municipality that meet those various governmental zoning as they pick. We talked about that, but is that the type of thing that comes to mind?
Mr. Chairman, Representative, we're getting into weeds a bit further than I had thought we might be here, but I was going to try and pull up a county-specific agreement so that I can share with you some of the parameters that are in place, and it'll take me a second to do that. Maybe I can go through some of the other amendments and come back to that so you can get an understanding of where my commissioners have been working, and it hasn't been necessarily in the zoning space.
Okay.
Go ahead. Mr. Chairman, I did want to briefly, look at this. Mr. Laramundi is pretty quick. He went where I was going to take a look at. And this is specific to a Converse County agreement, which I would say Converse County is probably similar to what you're seeing in a number of the jurisdictions right now. So
So I think we need to clarify what you're reading from. You're reading from the agreements that the providers have put together, conditions that they agreed directly with the county commissioners to do in order to get, the consensus of the county to move forward with it. So and these are just things that are promises that are made by the providers and when they bring it to the county, correct?
Yeah. Yes, Mr. Chairman, this one that I'm going to read to you is specifically from an agreement between Converse County and 307 Horse Racing. And here are some of the terms that are included. They're granted a license to operate for a term not to exceed 5 years from the date of the resolution. They have to submit an application no later than 60 days prior to the expiration of the resolution, that they shall include a presentation of all financial and community benefits of the operation, that the renewal term should be for no more than 3 years, if granted, and that's a particular part of it. The renewal application may only be denied for good cause. So all these things that you're talking about and that were in my original, you're starting to see some of these. It has in there that the commissioners have the intent to deny the renewal, that they shall provide written notice to the permittee and provide an opportunity to be heard at a hearing of the commissioners, and that the denial shall be supported by specific terms in writing, and that the revocation, the right to revocation, should be for good cause, and that the permittee shall provide information on tax revenue and other operational issues throughout the term of the approval. So that's one. I know there are others that are out there that do have other provisions, and perhaps Laramie County has different provisions, but that's.
Mr. Chairman, there was only two things, that the financial benefits and then the tax revenue, that are in addition to what we have in here, because we talk about due cause and being warranted. So, but that's very helpful to understand the types of things that you're considering. It was certainly not. It's helpful. Thank you.
Yeah.
But yeah, just to follow up on that, the only difference is that that's the county making that agreement. And if you're in the Derby here in downtown Cheyenne, we're saying that that agreement probably ought to be with the city and not with the county.
And Mr. Chairman, I'm not arguing that. I have not argued that.
I think you are.
Mr. Chairman, you beg to differ.
Okay. Okay, next amendment?
Mr. Chairman, the next amendment is on page 6. And I just wanted to briefly talk to Senator Kinski's question about specific locations. I won't be able to answer where this should or shouldn't be in statute. It certainly could go somewhere else in statute, but this inclusion of the specific location is intentional. We have a situation in a few of the counties, Natrona County is probably at the tip of this spear, whereby, right, wrong, or indifferent, the county commissioners granted approval to at least one of the operators for a specific location and all other locations that they might want to have in the future. So in that instance, the board has no ability to control where those additional locations might exist in the county. And so this is.
Was that at the request of the applicant?
Mr. Chairman, that's my understanding, yes. So, Mr. Chairman, this is intended to try and make sure that when we authorize these approvals, that we know where those exist within the county. That said, Mr. Chairman, my amendment here is not specific to that. It is specific to a local jurisdiction having the ability to set minimums and maximums within the bounds of existing state statute. So obviously this will have to be amended, but we do believe that counties, municipalities should have the ability to dictate how many machines go into a particular location.
Mr. Chairman,
Go ahead.
I know it's not part of your amendment, but you just discussed it briefly, and that is the specific location. Would you also agree that that specific location would apply to the renewal? That the renewal would not just be a blanket renewal, Mr. and Mrs. Operator, take your operation and put it wherever you want in the county, but rather that renewal would be subject to an exact location or address? Would you agree that that's approval and renewal are identical in that regard?
Yeah, Mr. Chairman, and Representative Walters, as I was listening to that conversation, so long as you're going to be in the same location, it seems to me that that you ought to be able to move forward with the same number of machines. But if you're moving across the street or somewhere else in the community, that yes, that should be part of the renewal process.
Okay, committee, before we go on, we could spend the rest of the day on this bill alone. And that's going to defeat our purpose, and we're not going to come out with a final product. So I think what we need to do is just move on from this bill, get your comments, and so it's going to land somewhere, but it's not going to, we're going to obviously not have a final one today. So we may have to take it back to the working group and have some type of actions that we take based upon your comments. And but I'm just reading the tea leaves of this committee up here and these discussions. And I mean, this is just probably not the right time and place to get everything done by 5 o'clock or 4:30.
I said 10 PM though.
It could be, but and so, and what I don't want to happen is have the same argument for 6 more bills. So what we need to do is see if we have a consensus of the bills that you folks think are ready for prime time. And in the meantime, I think we'll take a short 10-minute break. We'll kibitz with our committee and kind of decide how, but a little feedback from you on those issues on the reigning bills before we go down another rabbit hole. All right?
So I was reading that same 5 was getting
Okay, we're back and it's barely 10 minutes. So, ladies and gentlemen, are we online or are you live? Here's what we're going to do for the rest of the day. We're going to reformulate the working group and review all the bills and get your comments. And so the only other bill we're going to consider today is a consolidation bill because there's no policy in it. It's simply taking all the pieces, components from all of our different parts of the statute and putting them in one place so that our statutory framework is reasonable and understandable. But for all of you that have comments on any of the remaining bills, we'd like you to submit those in writing if possible. And then sometime next week, we'll figure out a date and place and time to have a working group meeting to review the other bills. And then the plan would be in December, when we meet for, I believe it's starting on the 9th of December, we'll make a time during that period to review any bills that we believe that we have a general consensus, both from our side and your side, to move forward with. Does that help everybody? Okay, so that's the current plan. So with that, Tamara, we'll go back to you, and I think we're going to draft Bill 65, right?
All right, if you're ready, Mr. Chairman.
We are.
All right, we're on 25 LSO 0065. This is working draft 0.5. This did not change from your meeting in September. You started the concept off earlier this interim with considering recreating all of the gaming statutes and involving the Department of Revenue as a entity over the Gaming Commission. That idea was decided against, and what you've got now is just a somewhat renumbering of all of the existing statutes and recreating or amending where necessary to make everything fit together. The easiest way, I think, to conceptualize it is on page 1, beginning on page 1, page 2, and page 3. In the staff comment, it shows what the new structure in the Wyoming Green Books would look like. And so all of the provisions, other than the criminal law provisions, would move to Chapter 24 within Title IX. And Title IX is administration of government. That's where your Wyoming Lottery Commission is and would stay. That's where your Gaming Commission newer statutes are for online sports wagering. But it would take all of the provisions that are in the agriculture title and move them into this Title 24 for the Gaming Commission. So Article 1, that's your existing online sports wagering. We move that into Article 6. So that way you can begin the article in Article 2 with your general provisions, definitions, the creation of the Gaming Commission, the specifics of the Gaming Commission, the supervision of the Gaming Commission. Then Article 3 would be your charitable gaming statutes. These are currently within the criminal law definitions. This would move them to their own article. You'd pull and recreate definitions. You'd recreate the provisions for bingo games and pool tab games and for Calcutta wagering. Article 4, you would move and recreate the paramutual provisions, the horse racing, simulcasting, and historic horse racing type of things, recreate that all within the new Article 4. Article 5 would be limited to skills-based amusement game. That sort of started out within paramutual wagering, and then it moved a bit to its own section, and now we'd move it again here to skill-based amusement games. Article 6 would be the existing online sports wagering article, pretty well just recreated and renumbered from the existing statute. Throughout, to do this, we need to do it in several sections. Your section 1 is what you need to create new, and generally what this means by create new means it has a new number. There wasn't an existing provision that, or number that we could tweak to amend, so we have to repeal it and recreate it new from existing places of law. Very little is new to this bill draft or is recreated or created wholly new. It's just taking from other places in statute. You can imagine cutting out provisions of the Green Book and pasting them together within this new language. And that is, continues on page 4, 5, 6, and on to page 7 would be a new article for charitable gaming. And create new by pulling from the existing definitions within criminal law that currently excludes the types of charitable gaming that are not considered gambling, that they're allowed. Same thing on page 8 for bingo games and pull tab games. And on page 11 for Calcutta wagering. On page 13 are a couple of provisions that we needed to recreate and by creating new, because of the way that skills-based amusement games grew out of paramutual events. The definitions are all within the agriculture title 11, kind of smushed together. So we separate those out into Article 5, skill-based amusement games, recreate all of your definitions as it exists in existing statute right now for establishment, operator, skill-based amusement games. And you can kind of see on page 14 and 15 where the challenges come when you're working other bill drafts this session that are going to amend this definition. You see the challenges of creating them new in this bill draft, or you might have another bill that's going on at the same time to change what a smoke shop is. And so when I get to the last section, I'll try to address one way this bill tries to anticipate that, but really, as best drafting practices, it's not to try to anticipate every move the legislature could make, it's try to make each piece of legislation stand on its own, and to be mindful as we're amending them, and to actually just conform on second reading or third reading or joint conference committee if you have to make legislation work together. Simply because you can't anticipate everything the legislature will or could do. On page 16 begins the amend section, and there is mostly just conforming the numbers within existing statutes and other provisions of statute besides the gaming statute to make sure all your references point back to the correct numbers now that we're changing and renumbering the statutes. Section 3 is the amend and renumber section, and these are the statutes that we could reuse by giving them a different number, and then just tweaking them slightly. Also within this text is something funny that we have to do when we amend and renumber, and you see it on page 23, is when you want to repeal a provision that you're renumbering, we have to move it in the Green Book. And so we have to have a place to say this was repealed by 2025 session law. And so you see on line 22, where I've left in the paragraph 2 and then stricken text. That's not a common way to repeal things in your normal bills, but here it would be revised by bill processing to say in the Green Books, paragraph 2 was repealed by this session law, whatever it ended up being. Page 25 contains just a little bit of conformance with may versus shall language. That's a drafting practice. And the rest of the changes are conforming the numbers and article references. Page 28 and 29 are more examples of trying to keep in the existing statute numbers where you're repealing them. Page 28 and 29 are all of the references or definitions for skill-based amusement games. And because you're moving those to their own article for the skill-based amusement games, you take them out of this article here. Page 30 and 31 is again, striking some existing provisions that are recreated in the create new of this bill draft. This is some of the general provisions for the Gaming Commission. These would be created new within your first article, Article 2, where it has all the general provisions for the Gaming Commission that are recreated from existing law. Page 32 and 33 don't have changes, and the reason they're in this bill draft is because when we amend and renumber the entire section. And so it's brought in context since it all has a new number. On page 35 is just a technical conformance. Page 36, same. Page 37, I think 38, 39, 40, 41, 42, 43. Most of, at least, I guess all of 42 are just some technical changes, some improvements that through the drafting process, I also thought we should make, myself and other staff members who reviewed the bill. Page 43, this provision is for criminal history on line 13 and 14, and this is just to make this more broad in one of the ways that we conform this section to kind of conform all of the duties that are being done by the Gaming Commission. Page 44 and 45 are striking provisions for the licensure of charitable gaming because we're recreating those earlier in the bill. The same thing on page 44, subsection O, we're recreating this charge to the commission to exercise enforcement of the gaming laws. On page 45, this lines 15 through 20 are stricken because we're recreating those earlier in the bill for the Attorney General at the request of the commission to prosecute. On page 46, 47, 48 is just conforming the statutes or section numbers that are directed. On page 49 is renumbering all of the online sports wagering, just so we can move it from the beginning of the article to the end of the article. So the beginning of your article has your general provisions, which is the standard kind of practice for drafting. You start with the general and then you get into the specifics. This just changes the article and eliminates definitions that are recreated and points to the statute numbers that would be relevant after you get done with this bill if you enact it. So I think that takes you to the next section, which is on page 74. You have some statutes that you don't have to amend and renumber. You can just straight renumber and leave them exactly as they are, but make them fit where they're going to go. And so that's what section 4 does. We don't reprint them if they're just a straight renumber. So if somebody wanted to see those sections, they would need to open the green books and look at them and then know that they weren't changed, only the number will change. Section 5 is the repeal of provisions that are renumbered by this act. And so it is a little bit complicated to track what's being repealed. The practice is to name the statute and as it's renumbered by the statute, and then say that's repealed. So if there is any ambiguity, but it does take, when changes are made to the bill, if policy changes become brought into this bill and changes are made, it does take careful tracking to make sure we're not messing anything up that's later repealed. The staff comment shows you areas that are repealed that aren't otherwise noted in the bill. And on page 75, those are those charitable gaming provisions that we're repealing within the definition section of the criminal law statutes to recreate as a licensure article within this bill draft. Section 6 attempts to address the intent of the bill, and that's that this act is just to consolidate statutes. And if there's any other act adopted by the legislature during the same session, that act shall be given precedence and shall prevail over the amendments in this act to the extent that such acts are in conflict with the act, except that the provisions of such acts shall be incorporated by the legislative service office into the conforming or sequential statute section numbers. So if you have a definition of smoke shop in this bill, and it's exactly as existing law is, and you come in with another bill and have another definition of smoke shop, what this section is intending to say is that that new definition of smoke shop shall trump the old definition, but give it the right number so it fits where it will be in this bill. So you don't just have something hanging out there in Title 11 that no longer makes any sense. I think that you're gonna have to, and your staff are gonna have to really be careful if there's a lot of policy changes and make sure that perhaps this bill gets passed last, so that way we're able to make sure that we're conforming whatever we can, or use the reviser's bill as necessary if conflicts exist.
Okay, any questions for Tamara? It's always fun to have a 80-page bill. Okay, any public comment on the bill? Seeing none, we'll close public comment. We have a motion on the bill. Move to pass and seconded. Any discussion? Seeing none, roll call.
Members of the committee, the motion is on 0065 working draft 0.5. Representative Henderson. Aye. Representative Larson. Aye. Representative Sherwood. Aye. Representative Stith.
Aye.
Representative Walters.
Aye.
Representative Zwanitzer Dave votes aye by proxy with approval of the chair. Okay. Senator Anderson. Aye. Senator Garou votes aye by proxy with approval of the chair. Senator Nethercott. Aye. Senator Salazar. Aye. Co-Chairman Kinski. Aye. Chairman Nicholas.
Aye.
Mr. Chairman, the motion is agreed to. House bill or Senate file?
House. Okay. I think for the rest of the day, that clears the deck. Anything else, Don?
Mr. Chairman, just a quick preview. We anticipate the budget hearings will commence on December 9th and conclude through that week. There will be somewhere around 24 to 30 agencies that we're anticipating supplemental requests from, including capital construction. We've also set aside time on the agenda for the bills that you have re-referred to the working group, as well as the items on the shooting task force that were also re-referred. Of today's activity of consequence, you did approve the ECA, or external cost adjustment, for the K-12 model, consistent with the Joint Education Committee's recommendation. You received numerous updates, which I will not specify in completeness, and you also adopted the most recent gaming consolidation legislation. Mr. Chairman, on your December 9th meeting, you will, the first day begins at 8:30 p.m., and all subsequent days will begin at 8 a.m. And I believe the chairs are at least reviewing that agenda, and we will post it as soon as possible. With that, Mr. Chairman, I'd be happy to stand for any questions, and if not, thank you.
Mr. Co-Chair, I reviewed the draft of the letter to the governor on the ECA. I haven't seen the final to initial it with you.
Of the letter?
Yeah, to the governor on the ECA. No, I've reviewed the draft. We need the final.
Mr. Chairman, that is
the final, I think.
Are we supposed to initial off on the final?
I think we did it electronically. I did. I just sent my approval to Matt.
Okay, I signed it. I signed the draft. Is that enough? I don't need to sign the final.
And
Okay.
you gave that to
All right.
Matt?
Yeah, yeah. Okay, thank you, Don.
Mr. Chairman?
Please.
Could we start at 9 on the 9th?
We could.
I was gonna ask if we could start at 7.
That way you can drive down that morning.
That's right, that's right.
That'd be fun.
We'll make that accommodation. I should also give a preview. Governor has a Western Governors Association meeting, so he will be presenting his supplemental budget recommendations remotely.
Is he taking his staff with him?
And then, Don, you anticipated next week, after you had some other things in hand, sending out the revised agendas for the week of the 9th for Bob and I to look at?
That is correct.
Okay,
Okay,
super.
with that, we'll stand adjourned. Thank you, Nick.
Thank you.